Okay, the clock has moved across to 4 o'clock, so I shall start proceedings. So, hello everybody, welcome. My name is John Phillimore. I'm the director of the John Curtin Institute of Public Policy, and I'd like to welcome you to this afternoon's session of Curtin Corner. And if you've never attended a Curtin Corner before, welcome. And if you have before, welcome back. It's great to have you here. Of course, I would like to begin by acknowledging the Whadjuk people of the Noongar Nation as the traditional owners of the lands from which we are hosting today's webinar here in Perth on this beautiful sunny afternoon. And wherever you're watching from, on your behalf, I would like to pay my respects to traditional owners and their elders past and present. We've been running Curtin Corners for about 20 years on a Friday afternoon with speakers from inside and outside the university on a range of topics connected to politics and public policy, broadly defined, and this afternoon is no exception. We record the sessions and we then put them up on our website, upload them to the website. It sometimes can take a little while. Unfortunately, Peter Newman's talk is still not yet up there. He was our last speaker, but we do have at least 3 of our talks from earlier this year, and we have talks from ever since COVID. All our online talks have been up on our website, so I do recommend you go to the JCIPP website and you can see previous talks. And if you go there, you may find 1 or 2 by our current speaker, Rob, because we were just talking then. We think Rob's probably done, he and Peter Newman are neck and neck, I think, in terms of how many Curtin Corners they've done. So you can go back and see some other work that Rob's done for us. So we'd also like to encourage debate, of course, and so later we will invite you to ask questions of our speaker, and we use something called Slido. That's Slido. It's extremely easy to use. You just go to www.slido.com and then you'll be asked to enter an event code, and our event code is JCIPP, as in the John Curtin Institute of Public Policy. So just go to Slido, JCIPP, up will come our event, and you can then submit a question, or you can like somebody else's question, and I'll then facilitate the discussion based on the questions we've received. So now I'd like to introduce this afternoon's presenter, Dr. Rob Guthrie. Rob is an adjunct professor at the JCIPP at Curtin. He was admitted to legal practice in 1982. He came to Curtin in 1988, and he lectured in employment-related areas, and he later became head of the School of Business Law, and then professor of workers' compensation and workplace laws. He's the author of several reports. He's basically the oracle on workers' compensation matters, and in fact, I'm sure he's given a talk for us before on workers' compensation. He's published over 100 refereed articles and conference papers. In 2010, he was sworn in as an assessor of criminal injuries until he retired from that position in 2023, and I'm sure he'll just explain a little bit about what that role involved when he gives his presentation soon. But Rob continues to write on issues relating to victims and survivors of crime. Last year was a big year for Rob. He won the WA Attorney General's Community Service Law Award for his more than 40 years of dedicated service through community legal centres, academia and law reform, and he also won the 2025 Law Council of Australia President's Award. So he really had a great year, and it was deserved recognition for all the great work he's done over the years. So Rob, thanks once again for volunteering to do a Curtin Corner presentation. It's great to have you here again. We look forward to what you've got to say, and then when you finish, I'll come back on the screen and you and I can have a chat and answer the questions from Slido. So over to you.
Okay. Thanks, John. You can hear me?
Perfectly.
Okay. Thanks very much, John, and welcome to everybody out there. It's a great pleasure to be back on campus, actually. It's terrific out there at the moment. If you haven't been to Curtin campus, you should, because it's a beautiful place. I'm going to talk this afternoon about the growing numbers of victim compensation claims. The title of my talk is Explaining the Growing Number of Victim Survivor Compensation and Support Claims, and just a brief footnote on terminology. All states have got forms of victim compensation schemes or victim support schemes or survivor compensation or survivor support schemes, and I might lapse into victim compensation. That's because, as John said, I was appointed an assessor in 2010 in Western Australia, and the legislation in Western Australia refers to victims of crime. And so sometimes I'll lapse into that, but I acknowledge that That's not necessarily the preferred nomenclature for people, and they like to be referred to as survivors. So please accept that it's just a legislative terminology issue for me. I'm going to take you through some slides and just talk you through some of these issues. This is sort of work in progress in terms of looking at what's been coming through from the data in Western Australia for the last 4 or 5 years. And the annual reports of the Office of Criminal Injuries Compensation are starting to show some very, very significant jump in claims. And I want to explain that and to really to speculate on why that is so. Just pausing here to say hello to my friends at the Department of Justice and also to the Department of Treasury. I understand that some of you may be interested in what I have to say. So to begin, most of you are probably aware, and if you're not, victim survivor compensation schemes were legislated probably actually since the 1970s, but certainly since the 1980s. Every state and territories had some sort of scheme which provided for compensation for people who were injured as a result of criminal activity. There's some variation in the schemes. They are all essentially legislated by the states and territories. They're state-based. In fact, the Commonwealth doesn't actually have its own scheme. They're all state-based or territory-based. They're diverse in the sense that some of them, as I indicated, talk in terms of victims of crime. Some talk in terms of support schemes for victims or survivors. The benefits, though, are generally uniform. Whilst the requirements for satisfying compensation levels may vary. For example, in some states, you're required to show that you've been injured as a consequence of a violent crime, whereas in Western Australia, there's no requirement that the crime be violent, simply that there be some criminal activity. All of the schemes provide compensation or support arising from a death through criminal activity, and all of them provide payments for medical expenses, rehabilitation, counselling, and some provide compensation for property damage. So there's some uniformity, although there's some diversity in the amounts being paid. Just as a matter of interest, Western Australia is probably the most generous scheme at present. And the reason for that is that it's maintained the same level as compensation since 2004, whereas a number of other states, in particular New South Wales and Queensland, have actually reduced their entitlements in some shape or form. So it's interesting that without actually increasing the benefits payable to victims of crime, WA has actually emerged as the most generous scheme. Having said that, the compensation payments in WA have not altered since 2004, and that's now 22 years ago. So there is an argument put by advocates for claimants and people who suffered as a consequence of criminal activity that it's probably past time to increase the compensation payable. But that's another story. For the moment, what I'm talking about is what's actually been happening in relation to claims. Briefly, I can say to you, if you look at the annual reports in Western Australia, there's been a massive jump in the number of claims for compensation in WA, and I'll come to that in a moment. What's happening internationally is interesting. In terms of research, there's not much activity in terms of research in other areas. The schemes vary around the world, as you would imagine, and in the US, for example, they have state-by-state schemes so that there's not a lot of uniformity in United States, but there is some research which indicates that there has been an increase in victims' compensation, largely driven by outreach programs. In other words, the compensation schemes have actually gone looking for claimants, and the outcome has been that they've received more claims. The only other research I could find, which was in Canada, related to an increase in claims in that country. And again, they thought that the expansion was due to victims' rights and increased recognition of family and domestic violence and psychological injury. Just to pause there, that kind of research is essentially saying that you can rationalise or you can speculate on why numbers of claims have increased. One is an external factor in that the scheme is actually pushing itself outwards and making itself known by whatever means possible. Outreach programs, for example, training of staff, becoming more available to the population. And then there are internal drivers such as changing the legislative provisions to increase recognition of various forms of injury. So those are some broad drivers. Those things really haven't so much been happening in Western Australia because for the past 22 years we've had stable legislation. So there's been no change in legislation. So the drivers are somewhat different in Western Australia. What's happening in WA is, as I mentioned, there's been a significant increase in claims since 2002. To give you an indication, when I first commenced as an assessor in WA, that was 2010, the number of claims that came through to the Office of Criminal Injuries was around 1,500 per year. By the time I left in 2023, that was around about 6,000 or 7,000, and the current number of claims for the last financial year in the annual report was around 12,000. So in the last couple of years, there's been essentially almost a doubling of claims in Western Australia. That's significant for a number of reasons. Firstly, of course, that means that there's a significantly larger payout made by the Office of Criminal Injuries. The Office of Criminal Injuries in Western Australia is funded by consolidated revenue, which means it's funded by taxpayers, and so the money comes out of budget. There's no cap placed on the office, so as the number of claims increases, so does the amount paid out. Hence, sometimes the interest in Treasury staff in how much has been paid out by the Office of Criminal Injuries. Other states have also experienced rises in claims. From the research that I was able to find, New South Wales currently is experiencing a 10% rise in claims, Victoria a little bit more at 18.3. The problem in Australia in relation to data gathering, as it is internationally, is that most jurisdictions don't publish specific data on victim survivor claims. So it's actually very hard to get information. Western Australia probably publishes the most comprehensive data of all the jurisdictions. And that's why I was able to look at the figures in WA so easily. But if you're trying to track down information from the other states, the major states, for example, New South Wales, Victoria, Queensland, it's particularly difficult, and the reporting is quite diverse, and there's no great match-up in terms of the data. So what we can say is that there's a broad increase in compensation support claims around Australia. Precisely how much and what is the driver for that is fairly speculative, but I'm going to speculate on those possible drivers. Firstly, one of the correlations that I noticed is that there's been a rise in violent crime universally in Australia. There is some data from the Australian Bureau of Statistics, which shows that nationally a 5% increase in homicide and 11% increase in sexual assault. Now, the importance of that is most homicides, in fact, all homicides, are likely to generate a claim for victims' compensation or support. By definition, a homicide is an unlawful death, and it's likely to give rise to victims in the sense that most jurisdictions will give an entitlement to close relatives of the person who's been unlawfully killed. So when you have a rise in homicide claims or homicide, it will almost universally have an impact on criminal injuries compensation schemes. Likewise, an 11% in sexual assault suggests that there is likely to be an increase in claims as well. In WA, there has been a rise in family and domestic violence and homicides related to family and domestic violence and sexual assault. In New South Wales, likewise, an increase of 7.3% in family and domestic violence. And Queensland has reported significant increases in violent crime since 2020. So what I'm saying here is there is likely to be some correlation between a rise in compensational support claims if in fact you have a rise in violent crime. So there will be a connection. I'm saying a correlation, and I won't say that it's necessarily a cause of an increase in claims, but it's likely that where you get an increase in violent crime, you're likely to get a commensurate increase somewhere down the track in relation to victims of crimes claims. For example, what that means in practice is that if there has been a prosecution and conviction of someone for homicide, sexual assault, family and domestic violence, that will almost certainly translate 2 or 3 years later into a victims of crime claim. And that's because most applicants will have to wait for the court processes to be finalised before they make a compensation claim. So there is a time lag. So the other correlation I make is generally in relation to family and domestic violence. Western Australia, some years ago, we were asked at the Office of Criminal Injuries, and the assessors were asked to indicate what percentage of our work was made up by family and domestic violence. And at that time, we actually did not keep a statistic on it because it wasn't a statutory requirement that we do so. Since the recommendation of the Law Reform Committee, probably nearly 10 years ago now, there has been data collected in relation to family and domestic violence claims. We were somewhat surprised. Our first guess was that there would be about 30% of all claims that were processed by the assessors would be family and domestic violence. But the first figure, and it's been consistent since, is around about 45% of claims in the West Australian Office of Criminal Injuries Compensation are related to family and domestic violence. So nearly half of the work of assessors will relate to family and domestic violence. And there is, in fact, some local Curtin research which shows that WA had the highest rate of FDV in Australia at one point. There's also data collected from the Australian Institute of Health and Welfare, which shows that 1 in 4 women have experienced intimate partner violence, and there has been significant increases in FDV hospitalisation. Now, just the point about hospitalisation is that it's when a person goes to hospital or seeks medical advice that often prompts a claim. And it's because, for example, that they may receive some invoice for medical treatment, which actually prompts them to consider how they're going to pay for it. And they'll seek advice around that. And someone will say to them usually, well, that's something that can be sent to the Office of Criminal Injury. So an increase in hospitalisation rates for FDV is significant. And the other statistics around a rise or a continued heavy numbers of family domestic violence does explain why West Australia in particular is showing an increase in claims. The other drivers are sexual assault. So if nearly half or 45% of the work of assessors in Western Australia is for family and domestic violence, then probably around 20 to 25% of the work of the assessors relates to forms of sexual assault. Usually, predominantly, about 70% of that is for women and girls, and the remainder 30% for usually young boys and some men. And in that mix is current claims, but also historic claims. And I'll come back to the issue of historic claims in a moment. So the data held by the nationwide research group, the Australian Institute of Health, show that there had been a 30% increase in sexual assault between 2010 and 2018. And one would expect that since 2018, there's been a similar data. In WA in particular, 21.6% increase from that time onwards, 2018 to 2021. Data from New South Wales, and you can see that there's not much line up between the sort of chronology of it, but New South Wales between 2019 and 24, a 42% increase in sexual assault, which is extraordinary. Queensland, 11% in the financial year before last. And Victoria noted for having the highest level of sexual assault recorded between 2014 and 2024. So almost universally, and if I haven't got data that's mentioned there, it's because it's not readily available. For example, Northern Territory ACT data is not readily available, and South Australian data is not easy to get hold of. So I've clustered together as much as I can from publicly available data at this stage. but it's generally showing a rise in sexual assault as well as a rise in family and domestic violence and violent crime. So what I said earlier was that if you're 20% or 25% of the work of the assessors relates to sexual assault of whatever form, then when there's an increase or a rise in sexual assault, that too is likely to have a flow-on effect with claims. So all of these things are not directly causative, but I'm saying that there's likely to be a very strong correlation between the increases that are taking place in these areas of crime. So just a couple of observations there. Most compensation support schemes have high levels of FDV and sexual assault claim numbers, like WA. So what data is available suggests that New South Wales and Victoria have a similar makeup to the profile of claims which is being assessed for compensation or support in those states. So if WA is a guideline, it's likely that the other states have similar profiles. And therefore, when you have a movement in FDV and sexual assault, it's likely that within a period of 2 or 3 years after convictions, that claims are likely to be made. And I've just made an observation there. If with the family and domestic violence claims, sometimes the proceedings are a little bit not so lengthy, and actually it's likely that the claims can be made in a shorter period of time. What we see with sexual assault claims is they frequently take longer to investigate, prosecute, and obtain conviction. They're frequently subject to appeal, and so it takes a long time sometimes for convictions to be finalised. FDV claims tend to be, the majority of those are actually dealt with more quickly in the magistrates' courts, whereas sexual assault claims are almost always dealt with in the district court or the children's court. And so those proceedings tend to be somewhat more delayed and lengthy. So in terms of making claims, and for those practitioners out there, we tend to see longer delays for sexual assault claims if they're multiple claims, and with FDV claims, they tend to be not so delayed in terms of getting an application in, but the complexity of those may vary the time that the assessor is able to finalise them. Just to be clear on that, what I'm saying is that where you have a complex claim like an FDV matter, which often will have a number of incidents, and again, the profile will vary, but often it involves minor assaults culminating in a significant assault, and often accompanied by breaches of bail conditions, breaches of violence, restraining orders, and the like, so that a person who's been subject to FDV will invariably be lodging not just one application, but multiple applications. Whereas sexual assault claims, in a sense, tend to be more straightforward in that often they are matters which have been subject to prosecution and conviction, and the complexity is not so detailed. Having said that, I'll come back to historic claims because they can be very complex. Okay, so there are other contributing factors. So on the one hand, I'm saying that when you're looking at and trying to rationalise why there's been such a significant jump in WA and probably the other jurisdictions, it's likely that that relates to these external factors, if you like, of the rates of crime. The rates of crime in relation to FDV, sexual assault, and violent crimes. All of those will, I think, logically have some downstream consequence in relation to what happens with criminal injuries claims. But there are other factors which I've observed certainly the last 5 or 10 years, which are also contributing to the outreach of the Office of Criminal Injuries and the other systems in Australia. For example, there's nowadays, I think we can say, significant public awareness and media focus on FDV in particular. There's been a number of national FDV campaigns. And at the bottom of that slide, for example, there's been a number of support systems being set up, the 1-800 RESPECT, and also a federal scheme, a national plan to end violence against women and children. And if you add that into the mix, there's been some very high profile cases which I think have been, by and large, had the effect of prompting or encouraging claims. Grace Tame's work, Rosie Batty's work, I think is self-explanatory in the sense that, particularly in Grace Tame's situation, she's made it plain, her support for sexual assault victims. Rosie Batty being very vocal in relation to FDV matters. The Brittany Higgins, somewhat more complex, but the ultimate result in her cases, and there have been numerous, was a recognition that she had been sexually assaulted in her workplace. And I think also significantly in that case, it was said by Judge Lee that for practitioners, it's very important to understand that inconsistencies in evidence around sexual assault must be viewed through the lens of trauma. And I think that was quite an important statement by him in that case. And it, I think, is encouraging for women because authorities, I think, are now coming to the view or will recognise that for too long, I think, when there were inconsistencies around the evidence given by sexual assault victims, this was regarded as tainting their evidence and making it more difficult for them to be believed. And I think what Brittany Higgins has achieved in a very indirect way through the various cases is that process, I think, has been enriched by what Judge Lee had to say in that ultimate decision. So there's very high profile cases which I think do not go unnoticed, and they do have an effect. And it's likely that they are some of the driving forces in relation to victims of crime claims. The other thing is around historical sexual assault claims. In Western Australia and in other states, there have been legislative changes which have extended the statute of limitations to allow for historic claims to be made in relation to child sexual abuse. This all arose out of the Royal Commission, which I'll come to in a moment. That, of course, opened the gates for common law claims, which allowed people who had otherwise been barred by statute to actually revive and renew their claims, even when settlements had been previously reached. So that what this led to, I think, was a lot of people thinking, do I have a claim? And what we saw and have seen at the Office of Criminal Injuries is a continuation of historic sexual assault claims. So it was not unusual when I was an assessor to have a range of claims which might be current in the sense that they'd happened in the last half a dozen years. But again, it was not unusual to get a claim from somebody who had been sexually assaulted in the 1970s, 80s, or 90s. And my comment on that is that it's likely that there had been some revival of claims due to the extension of the civil liabilities or the extension of time allowed for common law claims. The other thing was that there was such a thing known as the Ellis defence, which was removed by legislation. The Ellis defence essentially said, if you are suing the Catholic Church in particular, it was very difficult to do that because identifying the entity which could or should be sued was very difficult, and whether or not that entity had resources to pay a claim was very difficult. And again, that defence, which was often raised in cases against the Catholic Church, has been removed. And the effect of that is, again, opening the gates for some claimants. And these have some effect on raising people's awareness and people making inquiries as to whether they've got claims. So people who have been sexually assaulted, not necessarily through institutions, but it may have been through family members, may have thought, well, now is the time to make a claim. And the High Court's also played a role in this as well. There's been some opening up by the High Court. I'll go to the second case first, in that Wilmot case in the state of Queensland. This is a case where the High Court essentially said, look, we do not think it's appropriate to stay proceedings indefinitely. Often when church groups or other institutions had been sued, they would raise the defence saying, look, this happened a long time ago, witnesses have died, documents have been lost, it's impossible for us to properly defend this matter, there should be a permanent stay of proceedings. And the High Court has said that this is not necessarily the way to go. And it's been essentially been broadcasting to the other jurisdictions, or to the Australian jurisdictions, that there should be a more generous approach, in the sense that it should not be the usual form of orders that proceedings be stayed. So this has again opened it up for very old historic claims, which otherwise may have lapsed. And likewise, in a 2016 decision in the Alfred College matter, there was an expanded approach to vicarious liability without getting too complex. Essentially, the court in that instance has moved away from the traditional vicarious liability. Vicarious liability is the situation where traditionally the acts of an employee could make an employer liable. Where the acts of the employee were criminal acts, there was some real doubt as to whether or not the employer would be liable for the criminal acts of the employee. But in the Prince Alfred College decision, the High Court, whilst actually dismissing that appeal, made it clear that the idea of vicarious liability should be much broader approach. And where the employer has put somebody in a particular role, this may attract liability. And in that case, the person who had committed the criminal acts had been put in the position of a housemaster. And basically, the High Court was saying in this instance that was facilitating the criminal acts. But for other technicalities, it may have been that the employer was liable. So long story short is that the High Court also has, in a sense, contributed to opening up claims for institutional child sexual abuse, which leads me to the effects of the Royal Commission and national redress. So there was a Royal Commission between 2013 and 2017 into institutional responses to child sexual abuse. The report came out in 2017, and as a consequence, there was national legislation for a national redress scheme, which was somewhat revolutionary and fairly remarkable piece of legislation, because essentially what it did is it made the federal government the banker for these claims, and it made the states contributors to that scheme. The estimate by the Royal Commission was that there would be 60,000 claims for sexual abuse. At last count, there are 75,000 claims. That's a fairly large number, but just by the by, and a footnote here is institutional child sexual abuse is probably not the highest number of forms of sexual abuse, and across Australia, the most sexual abuse is still happening by close family relatives, which plays out in the state system. So this is a national system. The national redress system is set up to pay compensation to those people who have been subject to sexual abuse whilst in an institution. And those claims are going on. They've got another 2 years to run. My point about this is that whilst those claims are being made to the Commonwealth and funded by the states and the institutions, it's created a huge awareness around sexual assault claims, and it has prompted increased historic claims to the state systems. And often what it has also done is that invariably the person who makes a claim for sexual assault whilst in an institution will also make a claim under the state system for neglect or some other form of physical abuse which took place in the state systems. So the effect of having a Royal Commission is creating enormous awareness, but the national redress scheme has had some runoff effect to the states. There's been also, again, getting a little bit esoteric, but there's been other legislation which has probably prompted more awareness in relation to sexual assault. And remember, what I'm saying is that where you have rise in sexual assault numbers, you're likely to get a related rise in victims of crime claims. So there's an amendment to the Children and Community Services Act 2001, which introduced mandatory reporting in WA for the first time. Ministers of religion, that's significant. Early childhood workers, youth justice workers, and school counsellors and psychologists are all required now to report instances of abuse. Also, a little footnote there, the Industrial Relations Act was amended in 2024, has a new prohibition on sexual harassment. My point in relation to those fairly by-the-by amendments, if you like, is that they have also highlighted a sort of this fulsome picture of what's happening around these forms of crime. And the runoff effect is that it creates a general awareness that people have a right to compensation as a consequence of being injured through criminal activity. And the net result is an increase in victims of crime claims in WA, but also probably nationally. So I can't point to any one factor, but what I'm saying here is that there are a number of factors which bear upon why there's been such a big increase in WA. To summarise that, the national trends basically increased reporting of violent crime, increased victim engagement, the justice process. Just a footnote there. All states now have some sort of commissioner for victims of crime. We have one in WA, so we have advocates for victims of crime who operate within the justice system to be advocates for victims. And I think, again, that's part of the general awareness package which is happening. And in some states, there's been an expansion of eligibility for support and compensation, which of course attracts more people. So I'm coming towards the end of what I'm about to say, but I'm going to make a few final comments on what I've put together so far. I just want to say in relation to data, as I previously mentioned, it's not something that you can just look up. There is sort of no national repository of victims of crime data, which is unfortunate. ABA does assist with, in terms of crime data, but it doesn't assist with victims of crime data. And it's quite difficult to get a handle on what systems are paying out what amounts. But a couple of observations just to sort of finish off and some discussion points. So I think essentially I can say there's some correlations between violent crime, sexual abuse, family and domestic violence, and the increase in victim survivor claims. And that's because before the sort of significant increase, we knew that the profile of what assessors were doing comprised largely that group of crimes. Violent crime, sexual abuse, family domestic violence is what assessors do day in, day out. Just to complete the picture, for example, if about 45% is family domestic violence, 20 to 25% sexual assault, then what's made up the balance is there are a group of occupational claimants such as police, ambulance workers, teachers, nurses, who often have claims in the course of their employment. And apart from that group, then there are individual acts of violence, usually around nightclubs, hotels, where alcohol and drugs are evident, and they make up the balance of claims. So that's the mix. But predominantly, an assessor will be looking at sexual abuse, family domestic violence, and violent crime throughout their day. So there's a connection between the increase in claims, victim survivor awareness. I'm saying here that as well as those elements relating to the steady increase in violent crime, family domestic violence, and sexual assault, there's also a growing awareness in relation to those matters. For example, if you look at the West Australian, which I don't very often, but if you open that paper, you'll see that there's huge reporting on criminal activity, makes up probably 30 to 40% of the newsprint. If you open up any app and just say the ABC, for example, and have a look at the news, you'll see that there's quite a lot devoted to criminal activity, violence, and things and that like. So it's part of the national psyche, it's part of the news cycle, it's in the media, and all these things have some effect on systems. In addition, as I said, there's been some institutional changes, there's been changes in case law, there's been changes in legislation, and all these things are drivers. So where does that get you to in relation to why is this important? Well, it's important for a number of reasons. One is if you, at its very minimum, when you have a large increase in the numbers of claims being made upon a system. And John mentioned that I had quite a bit to do in past with workers' compensation. That's a good example. When you have a significant increase in the numbers of workers injured at work, it puts enormous strain on the insurance scheme. When you have a very strong lobby group like the insurers and the employers, they apply pressure to the government to change the legislation to invariably restrict benefits. And that certainly happened in the 1990s, and there's been some slow release from that, but essentially you can say in the last couple of decades there's been a very stable compensation system, but it's been restricted and confined, and there's a lot of caveats around making claims for workers' comp. All that's put in place because of the data showing increased claims equals increased payouts. At the moment in WA, you have got increased claims. There's been a general increase in the amount that's paid out. Again, for example, when I first started, Office of Criminal Injuries was paying out, the total payout was 20 to 30 million per annum. It currently pays out between 80 and 120 million. So that's been significant. And my friends in Treasury, for example, often have shown some interest in that number. So that raises a couple of issues. How is the system financed? In Western Australia, we're the only state that funds it entirely from consolidated revenue. So there's no other contributions made. It's not a kind of scheme like motor vehicle accident or workers' compensation where you can insure. For example, we have no scheme that actually says, you pay a registration and a part of that registration goes off and pays for victims of crime. There's no such scheme, and it's unlikely that that would be developed. But there are schemes in other states, and I think WA is now alone in not having this system, which allows for offender levies. So how that works is that where a person is fined and has to pay a fine, a portion of that fine or an addition to that fine, usually around 2 to 5%, is added to the penalty, and that amount is paid off to the Victims of Crime Fund. So one way of funding it is funding it through all of the offenders in the scheme. So this would be a levy on all offences, driving offences, whatever the offences might be, not just violent crime, but it would be all offences where fines are paid. And so the other states have managed to impose or have decided to impose offender levies and are funding their schemes at least partly through that. So it may be that Western Australia looks towards that modification in the future. The danger that I think we have to be very careful of as advocates like myself or victims of crime is that when governments feel the pressure and see the increase of claims and the increase in payments going out, one of the responses of government in the past, I know, has been to modify the scheme to reduce the amounts that can be paid out. And this, in fact, certainly happened in New South Wales and Queensland. So there's a precedent for it. One of the ways you do that is you put a number of gateways in the system and you exclude certain kinds of payments and you restrict the number of claimants that can be made in the system. I think that's unlikely to happen in WA because of the substantial awareness around victims of crime and the drivers that I've mentioned. I think it'd be rather bold of any government at present to say we've got a crime problem, but our response to that is we're going to reduce the payments to victims. One of the philosophies behind victims of crime schemes was to compensate the victims of crime because, in fact, it was the state which, in a sense, because it controls the police force and it controls the authorities which are put in place to control crime, when the state fails to do that, then the state should be responsible to the victims by paying compensation to them. So that's been a sort of governing philosophical underpinning of our compensation schemes. And when a state decides that it might reduce those entitlements, then I think that would be going the wrong way. So I think the alternative way would be looking at expanding the means by which the scheme could be funded. And one of those is offender levies, which are currently being used in other states. So those are my final comments. I think I'm going back to you, John, if you're listening. Um, uh, and I think I'm available now if there are any questions coming through on Slido. And if they're not, John, you probably will come up with something intelligent to ask me.
I will. My first question or my first request is going to be, can you just maybe stop sharing your screen there,
Yep.
and that way you and I can be on the screen rather than sit
Yeah,
down.
well, that's,
If you can't, it's okay. But
I'll,
and
okay,
and just stop sharing. There's a thing saying
okay,
stop sharing down the bottom.
uh,
Where it
okay.
says share, it says stop sharing.
It's actually share up the top.
Okay, then it says
Uh,
end sharing. If you can't do it, it doesn't matter. No, not
I,
on that part. On the actual bit down the bottom of the where it says
oh,
participants and all that sort of stuff.
you've lost me there, John, because it's not showing up on my screen.
In that case, it doesn't
I'm
matter.
sorry,
It's
folks.
okay. It's
Yeah.
fine. I'll try and work out how to do it. It's okay. That's okay. We've got the final comments up there, which will induce people to ask some good questions. We already have a few good questions,
Oh,
and
hang
just
on. Stop share. Wait a minute. How's that?
perfect. Here we are. We're on the
There we
screen
go.
now.
Yep.
Excellent. Well done. So just reminding everybody that we do have some questions, and you can put some questions in yourself. You just go to Slido, which is Slido. So www.slido.com. But once you go into Slido in the search engine, you'll come up. And our event code is JCIPP. So we already have a few questions, so let's get stuck in. The first question, which was asked very early on as you were talking, was, is the increase also related to legal firms fishing for business?
Oh, um, well, that's an interesting question. Um, my gut response to that is not so much. And the reason I'm saying that is, yes, there are firms who advertise for work in relation to criminal injuries, but it's not well known to be a lucrative area. That's the first thing. There are no costs paid in this jurisdiction. So when a person goes to see a solicitor to ask about a criminal injuries compensation claim, they will be personally liable for the costs. There's no insurance body or government body that's going to pay the costs. So the solicitors know that often the claims are not significant, and so that they tend to be rather modest in their costs. Another point is that 40% of the claimants in the scheme at present are actually unrepresented. So a large number, probably, one of the highest numbers of unrepresented in the jurisdiction, it will not actually be having to pay any fees anyway. And they will be driven simply because there's been some outreach program or some publicity which has entitled them to claim. So my gut feeling is I don't consider that to be a driver that's the ambulance chasing kind of thing. I didn't see much evidence of that. Having said that, still are a number of specialist firms that do this work. But I had a conversation with a lawyer recently, for example, and he said, look, it's really troubling when a person comes in with a fairly nominal claim, and he's talking nominal about 10,000. I really don't want to represent them because I'm going to take a large chunk of that. And he was asking me how would it, how best can a person self-represent in that sort of situation? So a lot of people end up with the community legal centres who do it for free. So that's the other thing, is that large group are self-represented and they're not attracting, there's no fees paid there, obviously. And then there is quite a big chunk of the people that do see lawyers, community legal centres, of which I'm quite familiar these days because I'm doing a lot of work with them. They pick up quite a lot of the victims of crime work, and they're doing it for free. So look, I don't think it's a big factor, but it's worth thinking about.
And just as an aside, and it's impossible to answer probably, but what's a typical, if there is such a thing, a typical payout? Are we talking? You mentioned there 10,000. Is
Oh,
that the sort of thing you're talking about, or what are we talking?
no, it's not at all typical. And the data on that is actually a little bit perverse. If you look at the annual report, the average amount paid per award is 15,000, but that actually doesn't tell you very much at all. For example, if a person has a sexual assault claim, there's been multiple sexual offences, and there's been significant psychological impact, they will receive up to 150,000 for each offender. Just to explain that, the scheme provides that it's up to 75,000 per offence. But where there are multiple offences by the same offender, it's double that amount. So invariably, a person who's been subject to sexual abuse over a period of time with multiple offences by the same offender is looking currently at 150,000. So many people would get somewhere near that for sexual offences, but it'll be quite different for minor assaults, single incident assaults. But again, you might have quite significant payouts for family and domestic violence if it's multiple offences and significant injury. So the compensation in Western Australia is unique in that each claim is assessed individually by an assessor, and it's the impact of the injury which is considered rather than the actual offence itself. So sometimes you can have a person who was convicted of GBH, but the injuries don't have as much an impact as an offence which is just a common assault. So what the assessor is looking at is the medical reports, the victim impact statements, any other information to consider the impact upon the individual. So it's individually assessed. But at the bottom end, for example, you get some occupational claims, ambulance, police, where people have been spat on, or there's some injury which is doesn't have any psychological overlay to it, and it's quite short in duration in terms of impact. So they will be at the bottom end, and a lot of those sort of claims made by police officers, for example, who frequently, sadly, get kicked, spat on, punched, they may be more down the nominal end. Having said that, there's many police officers who suffer significant injury, have been stabbed and bashed, etc., and they get a much larger amount. So the answer is there are, when a lawyer looks at a claim, they're looking at the impact and they're making a judgment about what's the duration of the hurt, in other words, and where it's long duration and continuing, that's more likely to be at the top end. Where it's shorter duration, physical recovery is good, it's more likely to be at the lower end. But you really can't tell. And what some other states do, I think, wrongly, and in fact the National Redress Scheme does wrongly, is they tend to be very much offender focused, in that they will say, what's the offence? Oh, very serious offence. Then that will get you more money, which I think is completely muddle-headed. It's actually the impact on the injured person which is significant.
Okay, a couple more questions. Helen Verhoff, you might know, and Helen, of course, great fan of
Hi, Helen. Yeah.
Yeah, and a great fan, great follower of Curtin Corner. Always asks interesting questions. Yeah. I mean, she put this question early on, probably just to help me out by showing everybody ask the questions, because she was saying, I'm guessing that this is an increase in reporting of FDV and sexual assault rather than an increase in the incidents, and positive changes in policing, which may see further increases. Do we know whether incidents has increased as well as just reporting?
Yeah, look, really nice point, Helen. Almost certainly there's been an increase in reporting of these matters, but there's obviously a general reluctance around reporting in relation to sexual assaults and FDV. That's always going to be a case of under-reporting, but hopefully, as time goes by, there's more supports offered. I saw in the time that I was an assessor that the changes in police practices were very positive, and the way that family domestic violence, for example, was being treated and looked at and investigated had changed, much more empathetic and more thorough. And I think hopefully as that filters through, it may lead to more reporting. I should say, in the rather technical side of things, is that it's not necessary to have a conviction in order to have a claim. If the offender's been convicted, that leads to what we call a Section 12 claim, and that's easier to establish. But there are a lot of claims for FDV in particular which were unreported, but nevertheless are still claimable. And that's because if there's some record of them, or the applicant can give a coherent statement as to what occurred, it's still up to the assessor, who can say, I basically believe that happened, and they can make a finding that an offence occurred. So it's a complex issue, but the greater the number of reporting, the more likely it is that there will be an increase in claims.
Sure. I mean, and Louise Lamont from Phoenix has asked a question which is probably related to what you just said, because she asks, for historical child sexual abuse claims, does there need to be a conviction of the offender? And with familial survivors, they may not pursue a criminal justice pathway, which is what you're referring to there, really.
Yeah, look, I mean, it's very interesting with the historic claims. They're very challenging. I was on a panel recently with the chief investigating officer on the historical crimes group, the historical sex crimes, and he says that people are still bringing sexual assault claims, old historic claims to them, and they're still investigating them. But we still would receive, and I'm sure what redress does, of course, the national scheme is that almost a great deal of the claims made to redress, which is the national scheme, institutional sexual abuse, were not reported, and there was no conviction. So there's a large group of people which have been able to make those claims as institutional claims, but we were seeing numbers of people who were saying that they'd been sexually abused. Now, it's critical of the age here because in WA, the scheme was only introduced in the early 1970s. So before 1970s, there is no entitlement. But every now and again, we would see claims from people in the 60s and the 50s, and we'd have to say, we're sorry, we couldn't compensate you because there was no legislation then. But after the 70s, there was a form of entitlement, and it was based on the date of the offence, and the entitlement was based on the year of the offence. So this is just another esoteric issue, is that the person who makes a claim for offences after 2004 could get up to 150, but the person who makes the claim prior to 2004 would get lesser amounts and lesser as it got older and older. So some of these older claims were being made, and to answer the question directly, without conviction, but people were coming to Office of Criminal Injuries saying, this happened to me, this is my statement. Sometimes people would go to the police and the police would say, look, we believe you, but the offender's dead and we can't prosecute anyone. But that would still be a claim that could be made to the Office of Criminal Injuries. The police might say, look, we believe you, but we don't think we can get a conviction because the standard of proof is beyond reasonable doubt, and there are some issues, and we don't think we'll get to that standard. But again, people might be able to satisfy the assessor that on balance of probability, that the event occurred and that there was an offence there. So yes, we were getting claims where there had been no prosecutions with those historic ones.
Thanks. Sort of leading on, maybe also Peter Abetz, who also was a former Curtin Corner presenter from many years ago, former state MP. Peter asks, what's being done to weed out false claims for redress? I mean, obviously, you're getting more claims.
Oh,
You've had a lot of claims. I mean,
yeah.
how do you deal with
Okay.
those? I assume there may not be a high percentage, but I'm sure there are some. So how do you deal with that?
It's not in my bailiwick because I was dealing in the state jurisdiction. And I can say pretty confidently that in the state jurisdiction, there was very low levels of fraud, like very, very low numbers. And one of the reasons for that is that most of the claims had been investigated in some shape or form by police. So there was invariably some sort of police brief, and that was quite a good gatekeeper for the assessors. The difficulty with the redress scheme is most of those claims, and I'm guessing here, but most of those claims had not been investigated. And so a lot of it depended upon the veracity of statements and the material that was provided by the applicant. And I venture to say that that does potentially lead for, people who want to take advantage of that for fraud. And I know that there has been some talk of that. I've got no idea what the numbers are. I do know from a friend of mine who is an independent decision maker in that redress scheme that it's something where quite a lot of energy is being devoted to investigating those claims. I can't answer it except to say it's really disappointing that that's happened. I don't think anyone dreamt of that when the scheme was being proposed. Obviously, the intention was to provide support to people who've been through, dreadful situations through institutional child abuse, and to think that that might be taken advantage of is really awful. But all I can say is in the WA scheme, the prospect of fraud is very, very low.
Okay. Some quick ones now. The quick question was just, is there any correlation that you know of between FDV and FIFO? That issue of, I mean, there's been talk about, the implications.
Yeah. Look, it's an interesting conversation because just to slightly digress, during COVID, there was a lot of talk about how COVID would actually impact on FDV numbers, and I think there was some evidence around that. Uh, it was hard to tell whether that translated into increased claims because of the general time lag, but there was some evidence that restricting people to home and they couldn't get out into the workforce, etc., was creating greater pressures at home, and that there was likelihood of increased family and domestic violence. But that's an area of deep research by others on campus. I know Professor Chung here at Curtin has done some work there. But in relation to FIFO, I know that there was the inquiry into FIFO and some of the concerns around mental health in relation to FIFO workers has been well established now. What I would say is there's invariably a correlation between alcohol, drugs, and family and domestic violence. And where you have, alcohol, drugs, etc., you have other pressures in the home, then you invariably, there are tendencies towards increase in family and domestic violence. But I'm not the person who would be doing that research. It's for bigger brains than mine. But I think it's a really worthy area to looking at.
Okay, quick follow-up from Helen again. She was curious to know if there have been any successful claims for the impact of illicit drug addiction, or is the illegal act of using drugs disqualifying? So it's not so much the drug addicted person causing the problem, it sounds like, but this is more the impact of having an illicit drug addiction. Anyway, what's the issue there?
I think I know where that's coming from. I think you've got to go back to basics, is that compensation is payable to a person who suffers injury as a consequence of an offence.
Yeah.
So that if they've been taking illicit drugs and they suffer ill health because of that, then they are in fact committing an offence which would disentitle them. So, but to turn that on its head, what we did see is that sometimes people who suffered significant physical injuries would become addicted to opiates or, in fact, some other illicit drug. And one of the challenges for the assessor was to say, what is the effect of this injury? Has there been an intervention by illicit drug taking, or is it a sequelae to the physical or mental injury? So often when you're assessing a claim, you would be looking at the contribution of drug taking to the injury which was caused by the violent crime. And that could be complicated, particularly if the person had been a drug taker before. So what we were looking at as an assessor is whether the injury caused to the person by the criminal act had actually elevated or accelerated or aggravated the drug taking. So we would not disqualify a person because they took drugs. And in fact, sometimes the injury precipitated the taking of drugs and could aggravate it. So it's a really interesting question, Helen. To answer your question directly, a person who's taking drugs, if they are illegal, would not have a claim directly, but a person who takes drugs as a consequence of an injury may well have a claim.
Right. Tony Proposh asks, with a doubling of claim numbers, is there to be an increase in assessors to avoid undue delay in awards, which I'm sure is a subject dear to your heart, and the Department of Justice may have also some issues.
Yeah.
Some thoughts on this.
I have to say hello to Tony. It's nice to hear from him again. Tony was very much embedded in the criminal injury system and lodged many applications while he was active. And we've had many conversations over the years. And I think it's a very good point he makes, is that currently there are 5 assessors. When I was doing the job, there are just the 3 of us, and we were barely coping. Now that the numbers have doubled, there's a very strong argument, I think, for more people on the ground to process the claims. I think it's something which is experienced by every jurisdiction. I'm sure that the district court, the magistrates court, the Supreme Court would love to have more judges. Coroner's court, everybody would, like to have more people, doing the work. And I guess it's squeaky wheels get the oil. I think criminal injuries is squeaking quite loudly at the moment, if I get Tony's point. And I think the problem is, the corollary of more claims means that if you've got the same number of people making decisions to finalise those claims and make awards, is that at some point there's going to be a backlog, and currently there is a significant backlog. Just getting back to your original question, John, is when you've got claims which are complex, some of those complex claims are taking a year and a half to resolve. The less complex claims, they can be 3 to 4 months, and that kind of disposal time is acceptable. But when it goes out to 1 year, 2 years, it's very, very difficult on victims and applicants, and nobody wants to see that. And things usually get worse as time goes on. So, yeah, look, there's a great argument for saying there should be more people on deck.
Okay. Here's a nice question. Has there been any work on the well-being of recipients years after obtaining compensation? Like, do you do follow-ups a few years later to find out what's happened?
Yeah, look, I mean, I think it would be terrific if the Office of Criminal Injuries had the capacity to do that kind of research. It's a tribunal, not a research body. And as you're probably hearing, it's got more than enough work on its plate than being able to do that. But we would like to know what the effect of finalising claims is. Just coincidentally, I've still got a couple of PhD students here at Curtin University, and one of them is actually doing some research on finalisation of workers' comp claims. And I guess historically, workers' comp claims have tended to endure, notwithstanding that people have received money. There's a huge fiction created in the 1960s that a verdict or a result or a finalisation cures everything. That's certainly not the case in my experience. And one of the interesting things about being an assessor is that you sadly do see repeat applicants. People who have been subject, for example, to family and domestic violence may get into a new relationship, which is again violent, and another relationship, which is again violent. In some communities, you get applicants who, have received several injuries over a period of time. So we actually did see what happens to people, and sadly, some of them had repeat circumstances which were not favourable. The other thing that assessors had, which was quite unique, is that we would make, under the legislation, orders for what's called a future payment, which allow people to have counselling into the future. And so the assessors would actually have a continuing relationship with the victims. And we could see, for example, if they were getting their teeth mended or they were getting their nose straightened or whatever it might be, but particularly in relation to counselling, you could see when they were doing counselling, how often, and when they started to engage in counselling. And that gave you quite an insight into the impact of an injury. To answer your question, no, we don't have the capacity to do that research. It would be valuable, I think. We try and make that best guess. That's probably not the best term to use, but when an assessor is looking at a claim, they're trying to look at what will be the impact of this injury into the future and allow for that. That's why we allow, for example, for future payments for treatment or for counselling. So there is research in other areas, but I haven't seen it in relation to victims.
Sure. I mean, just going on, just another question about research, again from Tony. Have you looked at any trends in figures on crimes against the person as opposed to just violent crimes? I'm not quite sure. You lawyers can tell us what the difference is. What do you mean about crimes against the person?
I think Tony's distinguishing when you've got crimes against the person as against crimes against property. And look, I think it varies. I'd have to go back to the WA police data, which is public. I think it shifts depending on the emphasis of police investigation. So crimes against property are things like burglary and stealing, fraud, theft, and those kinds of things. And at various times, I think they have elevated, and sometimes they've dropped, and then crimes against the person have increased. My sense is, without looking at the data, is that there's been a steady increase against crimes against the person. tends to have been focused on the family, domestic, intimate partners crimes. I think there is some evidence that crimes against individuals, such as street fights and things of that kind, have actually dropped, but family domestic violence, not so much. And I know over time, crimes in relation to burglary and things like that have gone up and down. Just on burglary, for example, that just because a person may not have been physically harmed, we had quite a few claims for burglary where aggravated burglary means someone's broken into the house and there's somebody home, and that can be quite shocking and give quite a significant psychological impact. So we had a lot of claims in relation to aggravated burglary.
Okay. Last question from Slido. I'll have one more at the end. Someone notes, you highlighted issues with the level of information disclosed between jurisdictions. Is there a role for a uniform disclosure regime?
Oh, I think so. There's lots of examples of it. If you look at work health and safety data, if you look at workers' comp data, I think probably even motor vehicle data, there's some overarching umbrella group that collects data in relation to those areas. There isn't a forum for this at the moment. We always thought in our office it would be terrific just to start, for example, with an annual conference, preferably in Bali, where all of the victims of crime people could get together and talk. Unfortunately, I think most of us were so busy that, the idea of getting together and talking about these things, how wonderful, but just people didn't have enough time. But there isn't a lot of information sharing, and there's certainly it would be terrific if that opened up. And I think if anyone from Department of Justice is listening, it would be terrific if there was some funding just to sort of start that process. I think it would snowball pretty quickly if you got people together and just started an email chain, would get things going, and sharing of data and annual reports and conferences and things of that like could be really valuable. But there isn't such a group at the moment.
Right. And my my point really, I was looking at yesterday's budget papers, the state budget papers. And am I right in saying, I mean, I looked at also the last couple of years, it's a very strange budget paper. It says the actual expenditure on criminal injuries compensation under the Criminal Injuries Compensation Act was 106 million. Does that sound right?
That would square with what I was suggesting, between 80 and 120. It's gone up and down.
It was 75 million in 2022-23, 80 million in 23-24, 106 million last year. The estimated actual for this year is 111 million, even though the budget was 41 million. And so so in the current budget for next year, 26-7, there's a budget figure there for $63.9 million. And in the subsequent out years, it's 41.7 million, which is obviously wishful thinking because it's gone from 75 to 80 to 106 to 111. So I mean, sorry, but why do we not actually just put in more realistic figures in the budget here for criminal injuries compensation?
Look, I actually never understood how it's been budgeted. All I know is it's paid out of consolidated revenue, so it is a line item. I know that we did have years where it hit 1 million, and I think even gone beyond, recently it was 106, but I think it went up to 120 at one stage. It does go up and down depending on the number of claims and the number that get processed. But look, I can't explain that, and it would be somebody, again, in the Department of Treasury that sort of puts that line item in. All I know is that the claims were paid because just to explain, an assessor is a judicial officer, so they're not subject to any ministerial or administrative interference. No one can tell an assessor what they should decide, how much that they should actually make an award for. It can be subject to an appeal to the district court, very low numbers of appeal, but even then, it's still an award which has got to be paid by the government. So those awards continue to be made and continue to be paid. So I really don't understand the mechanics of those estimates or those line items or how they do it. It's beyond me.
Yeah, it's interesting. It might be like Treasury's wish list, but they wish the number was 40 million or 60 million, but even though it's going to be way above. So is there a signaling device maybe to the department to try and get the victims, the offenders to start paying a bit?
Look, I don't want to be critical of the Treasury because I've got good friends there, and they're doing a great job. Yeah, look, it's been a long time since it's been 40 million, many years, 10 years. So it's hard to imagine where that number comes from. And as I said, the more realistic figure is really between 80 and 120,
Right.
and that's borne out by the annual reports.
Okay, so it's a significant it's a significant issue anyway, but
Yeah.
this funding issue is going to obviously have to be addressed at some stage.
Having said that, John, I think whilst that sounds like an awful lot of money, when compared with, for example, motor vehicle accidents, workers' compensation, it's it's very low indeed. And in terms of the impact that it does have, getting back to that question is what do we know about applicants after they've received their money? We would occasionally get some very favourable feedback from people, not just around the process itself, which we were quite proud to say was very trauma informed, but people would be writing to the assessor saying, thank you very much for this. It's great to be believed, and the amount has, freed me up to be able to move ahead. So, we think there's some therapeutic effect from this whole process, particularly with future payments when people can access them for treatment. Um, yeah, so I guess that's where I finish.
Okay, well, look, it's a good note to finish, and we've just ticked over to 5:16, so we're 1 minute after when I hope to finish. So,
Okay.
Rob, it's fantastic. Thanks very much for your once again very informative presentation on this really
Mm.
important issue, and hopefully our audience has also enjoyed it. And we had some good questions there, and good luck. Well, good luck. I know you're turning this presentation into a paper, a journal article, and so it'll be
Yeah.
interesting to see that in print as well. So, thanks very much for your presentation tonight.
Thanks, John, and thanks for listening in, everyone, and particularly Tony and Helen, who are still out there, which is lovely.
Thanks. And just to everybody who's still there, we're having a break for about 3 weeks unless I manage to find a speaker before then. But we will resume Curtain Corner on 29th of May when Mark Beeson, a professor UTS, is going to give a presentation on Australia as a middle power in the context of the Canadian Prime Minister, of course, talking about how Canada might try and approach the world at the moment. And so how is Australia approaching the world as a middle power? So that'll be on the 29th of May. Until then, thanks for joining us. Check out our website, and hope you all have a great weekend. Thanks for watching, and good night. Good night.